Well, going back to load shedding and its implications for businesses, it's been a suffocating few months for firms grappling with providing goods and services in the midst of erratic power cuts. Trying to mitigate against the blackouts has often been a strain on cash flows. So what options are out there for those jobs threatened by power cuts and employers alike? Thabang Rapuleng is the Director in Employment Practice at Cliff Decker Hofmeyr. Thabang, thanks indeed for coming in.
Thanks, David.
Well, I suppose the big question is whether or not employees can be denied a full salary if the company experiences some problems as a result of power cuts. What does the law say? Can this be done?
Well, in simple terms, David, it cannot be done.
Yeah.
It cannot be done in the absence of an agreement to that effect. It can only be done in a situation where you find the employer and the employees have entered into some form of a collective agreement whereby both parties agree to the change of their terms and conditions of employment. You will recall that the basis for it all, in the employment relationship, the employee only needs to tender their services. They need to avail themselves to tender their services. And once they have done that, they've done what is expected of them. In the event that the employer, for whatever reason, is not able to give them work to do, maybe they're supposed to be using machinery that relies on electricity, that cannot be blamed on the employee. Yes, it cannot be blamed on the employer as well, but the law does not allow for the employers to simply deduct what will have, the employees will have earned.
On the other end of the scale, and I suppose you partly answered the question, an employer, does the employer have legal space, for lack of a better term, to actually go ahead and renegotiate these contracts? Does that exist in the legal spectrum? Yes,
there is space for that. In fact, we have an example of it. If one looks at the Metal and Engineering Industry Bargaining Council,
yeah.
Their 2017 main collective agreement, they've negotiated a clause which they call short time, where in terms of which, if it happens that for reasons that are beyond the employer's control, the employees are not able to work, then those employees will be paid short time. Yes, there's a minimum that they will take home nonetheless, which I understand is 4 hours. But there is room for such negotiations in the labor space.
So when we talk about the working arena or the working space environment hit by blackouts and the disputes that may arise from that, that's one situation. But of course, there are so-called secondary effects. For example, employees not pitching up to work on time as a result of delays caused by power cuts. These are not sort of within the exact working space. But, you know, what happens in a case when employers are aggravated by an employee coming in saying that they are not prepared enough to work as a result of power cuts?
Yes. Well,
it's probably more casual than anything else, but I mean, it does exist.
Yes, and it does happen where you find, because of power cuts, traffic gets heavier, people arrive at work late, and they will say the traffic was bad and so on. But that obligation remains with the employee to make sure that they factor in those delays in their planning. It's for the employee to now know that on this day, especially with scheduled load shedding, they will need to know that on this day there's a scheduled load shedding. What does it mean for me? Does it mean I need to leave home an hour earlier to make it in time? If that's what it means, that's what they need to do. And obviously, employees have the room to renegotiate their starting hours with their employers, if that's possible, to say, can I start a bit later? Then instead of knocking off at my normal knock-off time, I work an extra hour or so to make up for the time that I would have missed in the morning. But purely pitching late without having made some efforts, it is a misconduct, and it will enable employers, obviously, to take action against the employee on grounds of misconduct. It will be for the employee to justify why they were late.
And then just finally, Thabang, I mean, you also have a situation that can arise as a result of power cuts, retrenchment processes by companies who just cannot survive under those circumstances. You will tell me that there are about pros and cons of this, and it just depends how the employee approaches a retrenchment process.
Definitely, the law does make provision for it. The law does allow employers to restructure on basis of the operational requirements or economic issues, and that could and does result in retrenchments. Obviously, it's one way. It should not be the first point of call. The employers are expected to also look at other options to avoid the retrenchments, but in some cases, more especially in small to medium-sized enterprises, you will find that the possibility of a retrenchment becomes a real possibility which the employer cannot avoid, provided that they follow the law, the letter of the law. It's regulated as to how you go about it. You need to consult. Depending on the size of the employer, there is room for facilitation by the CCMA or a competent bargaining council. Provided they follow the procedure, yes, it's an option that's available to employers.
Thabang, thanks very much indeed for coming in. That was Thabang Rapuleng of Klip Dekker Hofmeyr.